Today we have as our topic of discussion the National Commission for Backward Classes. The Constitution of India contains specific provisions relating to protection of rights and welfare of minorities, scheduled castes, scheduled tribes, and other disadvantaged sections. The Union government in this regard, by law, constituted several commissions to look after the implementation and working of special rights, protection, and welfare measures for these categories of people. The National Commission for Backward Classes, or NCBC, more popularly known as National Commission for Other Backward Classes, is one such commission established by an Act of Parliament to look after the matters pertaining to backward classes other than scheduled castes and scheduled tribes. The present statutory National Commission for Backward Classes was established by an Act of Parliament called the National Commission for Backward Classes Act 1993 that came into effect on 2nd April 1993. The Parliament of India enacted the Act in pursuant to the directive of the Supreme Court of India's judgment in the Indira Swayam and others versus Union of India and other case. The judgment directed the Government of India, State Government and Union Territories Administration to constitute a permanent body in the nature of a commission or tribunal for entertaining, examining and recommending upon requests for inclusion and complaints of over-inclusion and under-inclusions in the list of other backward classes or OBCs. The constitutional basis for setting up of such a commission is found in the Articles 15 Clause 4, 16 Clause 4 and 340 of the Constitution, which empowers states for making special legislation for the advancement of women and socially and educationally backward classes of citizens. Article 340 of the Indian Constitution expressly empowers President of India to appoint a commission to investigate the condition of and the difficulties faced by the socially and educationally backward classes and to make appropriate recommendations. Article 15 Clause 1, even though explicitly prevents states from making discrimination against any citizens on the grounds only of religion, race, caste, sex, place of birth, or any of them. The Clause 4 of the same article provides that nothing in this article or in Clause 2 of Article 29 shall prevent the state from making any special provisions for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. Similarly, under Article 16 Clause 4, the state is empowered to make any provision for the reservation of appointments or posts in favor of any backward class of citizens which, in the opinion of the state, is not adequately represented in the services under that states. By inserting such provision, constitution makers acknowledge the existence of socially and educationally backward classes other than scheduled castes and scheduled tribes in India. The sole objective of such provision was to provide socio-economic equality to the disadvantaged and weaker section of the society. The Constitution of India is not only a legal text that lays down rules of governing the country, but also a blueprint for socio-economic reforms in India. The commitment for socio-economic transformation is implicit in the preamble, directive principle of state policy, that is Part 4 of the Constitution, and section on fundamental rights of the Indian Constitution, etc. Since independence, the Union government has provided a number of benefits, protection and welfare programs for the scheduled castes and scheduled tribes, including reservation of seats in legislature, places in educational institutions and posts in government departments. As mentioned above, the Constitution refers vaguely to a third category of persons called backward classes, who are entitled to special protection against discrimination and to special benefits for their advancement. However, there was no consensus as to the criteria for defining backward classes due to the absence of single criterion which could be easily applied throughout India. It was because the status and economic well-being of the numerous intermediate castes between the untouchable group and the elite or twice-born castes vary greatly from region to region in India. In order to look into the matter, the first Backward Classes Commission was established in 1953 with Kaka Kalekar as its chairman to determine the criteria that should be adopted to determine whether any section of the population could be considered backward other than the SC and ST, and to prepare a list of such classes according to these criteria. The Commission submitted its report in 1955. Although the Commission expressed doubts about adopting castes as the basis for identifying backward classes, it however identified some 2,399 castes as socially and educationally backward and proposed the adoption of policy of reservation for these classes in government services with a range in the percentage of reserved posts from 25 to 40% in different categories. The Commission employed the criteria such as trade and occupation, security of employment, educational attainment, and representation in government services and position in the social hierarchy. The central government did not accept the recommendation of the Commission on the ground that it had not applied any objective tests for identifying backward classes. Later on, when Janata Party came to power, the second Backward Classes Commission was appointed on 1st January 1979 under the chairmanship of B.P. Mandal to examine the entire issue of backwardness, starting with determining the criteria that should be used to identify the backward. The second commission recommended the adoption of castes as criterion and identified 3,248 castes or communities comprising 52.2% of the population, roughly 350 million people, as backward classes. The Mandal Commission used 11 indicators of social and economic criteria which were grouped under three heads: social, educational, and economic. A decade later, on 7 August 1990, Prime Minister B.P. Singh announced that his government would implement the recommendations of Mandal Commissions and that consequently 27% of all jobs under the direct control or influence of the central government would be reserved for persons from backward castes. The announcement had generated large-scale upper caste agitation in North India, including several petitions challenging B.P. Singh government's decision. Ultimately, P.V. Narasimha Rao government passed the National Commission for Backward Classes Act in 1993. The Act extended to whole of India except the state of Jammu and Kashmir. Under the Act, backward classes means such backward classes of citizens other than scheduled castes and scheduled tribes as may be specified by the central government in the list. The lists of backward classes are prepared by the central government from time to time. Once a caste or community is listed in the central list of backward classes, they are entitled to special treatments provided by laws for such classes in terms of reservation of seats in admission to higher and technical education, jobs, in the employment of government services, etc. More significantly, the Act entrusted the central governments to constitute a body to be known as National Commission for Backward Classes to exercise powers conferred on and to perform the function assigned to under the Act. The Act also provides in detail the composition, power and functions of the Commission. Moreover, it has produced a new category of backward class called other backward classes in India besides scheduled caste and scheduled tribe. The Parliament Act of 1993 provides that National Backward Classes Commission shall be a multi-member body. Section 3 of the Act provides that the Commission shall consist of 5 members comprising a chairperson who is or has been a judge of the Supreme Court or of a High Court, a social scientist, 2 persons who have special knowledge in matters relating to backward classes, and a member secretary who is or has been an officer of the central government in the rank of Secretary to the Government of India. The above members of the Commission are nominated by the central government. Their salaries, allowances, and other service conditions are also prescribed by the central government. The members of the Commission hold office for a term of 3 years. However, they can relinquish their office at any time by addressing their resignation to the central government. Notably, members include the chairperson. Further, the central government can also remove a member from the office before the expiry of his terms under the following conditions: if he becomes an undischarged insolvent, if he gets convicted and sentenced to imprisonment for an offence which, in the opinion of the central government, involves moral turpitude, if he is declared of unsound mind by a competent court, if he refuses to act or becomes incapable of acting, if he absents himself from 3 consecutive meetings of the Commission, or if he so abuse his official position which, in the opinion of the central government, render his continuance in the office as detrimental to the interests of backward classes or the public interest. However, a member cannot be removed until he is given an opportunity of being heard in the matter. The Commission is vested with the power to regulate its own procedure. The Commission, while performing its function relating to inclusion or over-inclusion or under-inclusion of any class of citizens in the list of backward classes, has all the powers of a civil court trying a suit, and in particular in respect of the following matters: summoning and enforcing the attendance of any persons from any part of India and examining him on oath, requiring the discovery and production of any documents, receiving evidence on an affidavit, requisitioning any public records from any court or office, issuing summons for the examination of witnesses and documents, and any other matters which may be prescribed by the central government. The function of the Commission are provided in the Section 9 of the National Commission for Backward Classes Act 1993. Under Section 9, Clause 1, the Commission shall examine requests for inclusion of any class of citizens as a backward class in the central list of backward classes, and hear complaints of over-inclusion or under-inclusion of any backward class in the list, and tender such advice to the Union Government as it deems appropriate. Under Section 9, Clause 2 of the Act, the advice of the Commission shall ordinarily be binding upon the central government. And under Section 11, Clause 1 of the Act, the central government may at any time and shall, at the expiration of 10 years from the coming into force of this Act and every succeeding period of 10 years thereafter, undertake revision of the list with a view to exclude from such lists those classes who have ceased to be backward classes, or for including in such lists new backward classes. Under Section 11, Clause 2 of the Act, the central government shall, while undertaking any revisions referred to in subsection 1, consult the Commission. The Government of India has also evolved the criteria for exclusion of certain socially advanced persons or section called the creamy layer from the benefits of reservation available to OBCs in civil posts and services under the Government of India. The Commission presents an annual report to the central government. The report contains the full account of activities during the previous years. The central government places the reports before each House of Parliament along with a memorandum explaining the action taken on the advice tendered by the Commission. The memorandum should also contain the reason for the non-acceptance of any such advice. So far we have discussed about the genesis of the National Commission for Backward Classes and the constitutional provision relating to the establishment of National Commission for Backward Classes and the very purpose of establishing such commission and the various powers, function and composition of the commissions included in the National Commission for Backward Classes Act, which was enacted by the Parliament of India in 1993. The National Commission for Backward Classes, since its inception as a statutory commission in 1993, has been tendering advice to the central government from time to time pertaining to inclusion, over-inclusion and under-inclusion in the list of OBCs. A total of 30 notifications have been issued so far and a total of 2,343 entries. An entry means a caste including its synonyms, subcaste, have been notified in the central list of OBCs for 24 states and 6 union territories. The last such notification was issued on 8 December 2011. Since then, many more advices for inclusion, deletion of castes, communities, and correction in the existing list of OBCs have been received from the National Commission for Backward Classes or NCBC. Thank you.